This is Beyond a Reasonable Doubt with your hosts, Mark Garrigus and Gary Smith.
Wow, coming off some fantastic engagement last week and numbers last week, and back again with nothing but legal stories. We certainly have an embarrassment of riches, don't we?
It's been happening a lot lately. I mean, there's no shortage of things to talk about. You and I, our text chain is just, news story after news story after news story back and forth.
Yeah, I've got one personal one today that I want to lead off with. I've talked before about Dylan Taylor's case. Yeah. And there's, I think you might want to link, Gary, to the horrible video, which is embedded, I think, both at Courthouse News and Salt Lake City Tribune. I've talked about this case. This is a case where the young man was walking at a 7-Eleven. The officer rolls up and literally almost instantaneously shoots and kills Dylan based on a drunken woman's 911 call, for lack of a better. And the case was dismissed by the trial court on the basis of qualified immunity. We argued the case in the 10th Circuit Court of Appeals almost 2 years ago, about a year and a half ago. Today, the opinion came out. It was a very lengthy 93 pages in total between the majority and the dissent. And the majority affirmed the dismissal. The dissent, for lack of a better term, was blistering. Started off, I don't know if you've ever seen, for those of you who read appellate opinions, started off with just two words, 22 seconds. Yeah. And then the judge, if Gary's got it, he can read that first paragraph because it's something. Here it is.
I'm just going to play the video here in the background. I'm going to play it without the sound just so that you and I can talk over it. But yeah, I mean, this is one, you sent me that opinion and I opened it up and just, wow, 93 pages. And to have that be the outcome is just so demoralizing. I mean, we've shown this video for people who've been listening to Reasonable Doubt for quite a while. This is something we've been doing. But yeah, now the cop's out of his car and it's disgusting how fast this ends in tragedy. It's just...
There's Dylan right there, turns around and he's just walking.
Get your hands out now!
Yeah, and he says, put your hands out. He puts his hands out.
Get him out!
There you go. Boom. Kills him. Mind you, the dissent, Gary, do you have it there? Because it's really in a tremendous first paragraph. Yeah, you should read the dissent by Judge Lucero.
Let's see here. 22 seconds. That is precisely the time elapsed. 22 seconds from the moment Officer Braun Cruz stopped his police cruiser at a Salt Lake City 7-Eleven parking lot to the point at which he fatally shot 22-year-old innocent, unarmed Dylan Taylor. Dylan's crimes? Walking away from an unconstitutional police stop and pulling up his pants. The majority concludes, as a matter of law, that it was objectively reasonable, based on qualified immunity, to free Officer Cruz from any liability without a trial. This cannot be right. It is not the place of this court to resolve factual disputes as to the responsibility of Officer Cruz's actions. I am concerned about the extension of the judicially created doctrine of qualified immunity to shield officers even when there is a substantial and material dispute in the evidence, as I explained below. I most respectfully dissent.
Yeah, I couldn't encapsulate it better. I mean, it's a judicially created doctrine. The doctrine is, in my opinion, I don't know if there's a legal term, but complete bullshit. All it does is give courts the ability to clear their calendar. I don't, necessarily fault the majority because the U.S. Supreme Court punted two of these cases within the last 2 months. And but I guess the one thing about, for those who do practice or follow appellate law, one of the saving graces, if you will, of a 2-to-1 split over a very strong dissent is that increases the chances that when we go, we will go for, I'll tell you right now, no surprise, I'm just trying to figure out whether we go for what's called an in-bank review, which is to ask for the entire 10th Circuit to weigh in on this, or whether we go to the U.S. Supreme Court. I mean, somebody's got to take this. Somebody's got to deal with this. This is the kind of factual scenario that is expressly designed, in my humble opinion, to once and for all eliminate this monstrosity, this kind of judicially created Frankenstein that has absolved cops from doing their job. And I've said it once and I'll say it again. Good cops don't need qualified immunity. And there was no way to justify this shooting. And by the way, what are they so afraid of? Let a jury decide whether or not this is a good shooting. It's not like I'm in some ultra bad blue state, if you will. We're in Utah. Let the good citizens of Utah decide whether or not this is a good shooting, whether Dylan, as the dissent said, was walking away, by the way, from a cop who drives up behind him and then runs out, tells him, show me your hands. He turns around, shows his hands, and they execute him. And you don't have to take my word for it. Just replay the video Gary just gave you. Interesting, and it just occurs to me as we're sitting here, interesting that ruling comes out on the day before the press conference tomorrow for Alec Baldwin, a civilian who, by all accounts, accidentally shot a woman and injured the director on a set in New Mexico. And the police and the prosecutorial agency are both investigating whether they're going to charge. And I'm going to predict right now that they end up charging civilians with involuntary manslaughter. And mind you, we're not talking about an event that took place in 22 seconds. We're talking about an event that had at least 22 days unfolded, whether it was previous discharges, whether it was previous firings of somebody for lack of safety, whether it was many days before, an entire crew walking out, whether it was to save money, whether it was for age or anything else. There's just a certain amount of hypocrisy, institutional hypocrisy, that we're considering involuntary manslaughter in New Mexico. And this cop, the courts, as of right now, as of right this minute, we're not even talking criminal. We're talking civil liability. That they're saying you don't even get to get to a jury for civil fighting over other people's money. There is something wrong with the system when we can highlight those two situations: civilians versus law enforcement.
Yeah, absolutely. And that the Alec Baldwin thing is such a tragedy, but there is just, by all accounts, so much negligence there that you have a hard time believing that everyone walks away without some sort of a criminal, investigation and probably charges. I spent a lot of my day to day with some very high end actors and showrunners, and just to hear them explain the hoops you have to jump through when there is a weapon on a set and how seriously everyone takes it. It's almost impossible to believe that this could happen with an actor of such a high, Alec Baldwin is not, he might be on a budget, but he's not on a shoestring budget. There should be some cash there. So, yeah. Well,
there's, for a second, one of the angles here, which is interesting to me is, and I wish I had some kind of insight as to what's happening inside there. I don't. I'm just, based on my experience, you have the surviving victim is and remind me, Gary, to stick a fork in this term victim in a second when we go to our next story. But The surviving victim of the shooting was the director of the movie. The director presumably is the one who either hired or sanctioned the hiring of the assistant director, who apparently, if you believe the reports, was fired in 2019 for safety-related violations. You also have a director who presumably has control over his set, along with Alec Baldwin, who is the producer, over who gets hired as an armorer, who's responsible for safety. Ultimately, it's the producer and the director. Can you imagine if they charge somebody? And I say, if they don't charge somebody, one of the explanations is going to be, how the heck do they charge somebody whose direct report is the person who's actually ultimately responsible? So if they don't charge Alec Baldwin, if they don't charge the person who got shot, which would be, to my mind, going from the ridiculous to the sublime. If they don't, they're building there is a built-in defense for whoever they do charge to say, wait a second here. The director was praising me several days before about what kind of a job I was doing. The director, if you're the assistant director, knew my work history and hired me, and I'm sure there's conversations there. And all of those things I would submit are going to go into the moral calculus, the legal calculus, when they're deciding tomorrow in the press conference what they're going to announce or who they're going to announce or who's being investigated and what they're going to do. I mean, this case, by the way, the Alec Baldwin Rust shooting case, is not a question about civil liability. I mean, I will submit to you that the insurance company will probably tender the policy if they haven't already made the decision internally to do that, which means just pay it off.
Right.
They want to get out of that, and they don't want to pay litigation defense expenses. This case is all about the criminal exposure and who, if anyone, gets charged. And I'm not saying that they should, but I will tell you that in a case like this, people clamoring and with this kind of public focus, I would be shocked if there wasn't an involuntary manslaughter charge and more than one person who's charged with involuntary manslaughter.
Yeah, I don't disagree. You want to describe what we were talking about with victims earlier? We've got
let's go to the last story and we'll wrap this up.
Yep.
Also a shooting case, Kyle Rittenhouse. We've talked about it before. He's on trial or about to go on trial before I believe he's a Wisconsin state court judge. I think his name is Schroeder.
Yep.
40-year veteran. And he ruled today. I don't know if he's been on the bench for 40, but he's probably been in the criminal justice system for that long. He ruled today that the prosecution could not call the two people who were killed victims. And this has caused quite a bit of consternation that apparently Yeah,
it's just to clear this up. It's not only the two people who died. He also cannot refer to the surviving victim, surviving person, surviving shooting victim as a victim of, it's just.
You can't use the term victim. Now, People have been outraged about this online. People are saying, well, you can refer to them they can refer to them as rioters, looters, arsonists. And why is that? That's not fair. Look, I watched a case that my father tried many years ago, a murder case, ended up, I believe, in a manslaughter, but then was reversed. And on this very point, my father's argument was decades ago that the use of the term victim is a legal conclusion. You cannot be a victim until the trier of fact makes a determination that you weren't the aggressor, so to speak, because a victim implies somebody who is not at fault to some degree, and it's a legal conclusion. And the judge brought up the fact that another murder case he presided over many years ago was reversed because he let in a piece of evidence, a letter. And I've had this exact issue. I had it about 11 years ago in a murder case, a letter that said from a woman that said, if I die, my husband did it. So kind of reminiscent of OJ and Nicole and reminiscent of a case that I had. Letting that evidence in, it was reversed properly, I would submit, by the Supreme Court there, has been found in other courts, including in the court that we dealt with it, that you don't have this, there's a doctrine, if you will, of forfeiture, that basically if you're the one who's found to be responsible, that therefore you can't benefit by the fact that the person who's not there to either authenticate or testify and give you the ability to cross-examination, it's that you can't benefit from that. The problem is that it's the courts have ruled that's circular logic, because it assumes that you're the one who's responsible for the crime before you've been convicted or it's been submitted to a finder of fact. So I know at risk of upsetting those who think that there's a line in the sand to toe, calling somebody a victim is a legal conclusion. It was the right decision by that judge. I may disagree on whether You can call the people rioters, arsonists, or looters unless you've got evidence of that.
Yeah, I would guess.
And if you introduce evidence,
I think that's what he said. Is that what he said that's getting very misreported in the headlines is he said that assuming you have entered enough evidence into the trial, then in your closing, I'm not going to be able to tell you can't use those terms if you have already established it.
Which, by the way, if they establish it, I would submit that's fair game in a closing argument, which is persuasion, which is drawing reasonable inferences. If you show a video, for instance, of somebody who was later shot, who is climbing through broken glass in a store, or who is at the scene throwing a Molotov cocktail, I'm not saying they did in this case, but hypothetically, if that happens, then in a closing argument, you should be allowed to say that.
Absolutely. And I mean, in a trial like this, I mean, how many people were live on Ustream? And that is part of a lawyer's job to go through and find that evidence. And if they do find that, then I don't think it's unreasonable to allow them to use that term. If you have clearly established, look at this video, here is this thing. This to us is,
And by the way, one last point.
Yeah.
For those of you who might push back and say, well, wait a second, in closing argument, if they'd proven this guy was shot and there wasn't justification for it. No. Because that would dissipate and repeal the presumption of innocence. The law is that you are presumed innocent until the jury goes back into that deliberation room and deliberates. And that cloak of innocence follows you into that deliberation room. So obviously the closing argument precedes deliberations. So therefore, victim should be a verboten concept or word to use because it has not been determined by a trier of fact.
Well, I'm sure we'll be following that case closely as we look for stuff to talk about here on Beyond and on the Best Hour in the Universe. We'll have Adam hopefully back for the next Beyond and definitely back for the Best Hour this week. And we look forward to seeing you then, Mark.
I look forward to it, too. Thank you, Gary. Thank you, as always.
All right. Bye-bye. Thank you.
Bye-bye.
Thanks for listening to Beyond a Reasonable Doubt. Stay tuned for more bonus episodes coming soon.